Stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. This is John Vecchione, and I'm joined by Mark Chenoweth as usual. And the first thing I want to talk about as far as administrative law goes is that the Federal Trade Commission is at it again. The statute that animates the FTC basically states that it can go after certain things in the marketplace that are either unfair or deceptive. Now, that, if with a creative administrator, can be shoved into any possible activity they don't like. And boy, do we have an example today of that. The FTC has decided and has started to enter into consent agreements that prohibit the use of non-competes. Now, non-compete clauses or non-compete agreements are a long-standing tool between employers and employees that say that if you work here and learn our secrets and learn how we do things, you can then not, within this market, usually within 20 miles, but sometimes it's different, you cannot then go work at another place that does the same thing. And there are all kinds of permutations of this. The real crown jewels of this is, and where it had most use in the old days, was sales lists. The crown jewel of marketing and retail were the sales lists and who were the customers and who bought. And so if you worked for these companies, they started to say, look, you couldn't use these lists when you left, and that was always upheld because that was almost like your intellectual property. But they expanded, and the non-competes, I've litigated against them many times. They can become overbroad and they can become unfair. But guess what? The FTC is not the only actor in this area. All of the states have laws on this, and some of the states absolutely agree with the FTC and do not like non-competes. And these states have absolutely forbidden, you can't have a non-compete, except I have to say, all the states that I know of do that core group of sales lists and information from the company, that type of thing. You can't do, but that's more in the nature of not taking stuff out of your company. So the non-competes, and it's unclear right now whether the FTC is even going to allow that.
And in the nonprofit sector, it's not taking fundraising lists.
That's right.
When you leave, or
exactly, it's the same sort of thing. And but the non-competes are, you can't work here, you can't work there. And what's happened is, for highly compensated individuals, these non-competes are part of their high compensation. So if Coke doesn't want its somebody to learn everything it does to sell its sugar water, and go to Pepsi and teach them how to sell their sugar water, the fact is that carbonated sugar water, if you've got the secret on how to sell it better, they don't want you going to the competitors, and they will have a non-compete or they'll have financial incentives not to do that. But the other thing you can do, and the thing that makes non-compete so powerful, is you can actually get an injunction. So you can go to court and get an injunction for them to work for your competitor, and you can sue the competitor. So just the fact of these non-competes often stops you from going there.
And often stops the competitor from hiring you,
right,
if they know that you're subject to a non-compete.
Correct. And so what happens is, it does interfere with the free movement of labor. I don't disagree with that. But the FTC wasn't given power to regulate everything in the American market it doesn't like. And the problem with the FTC is, there used to be this old commercial for tomato sauce, and they're trying to convince the grandmother that it's as good as her sauce and that she can use the jar of tomato sauce. And the ad was onions. Oh, they're in there. Tomatoes. It's in there.
This is their old ragu ad.
Yeah,
for spaghetti
sausage.
sauce.
Yeah, it's in there, right? And then the son would say everything's in there. Well, the FTC, I want to regulate the world. Oh, it's in there. That's their story. And the fact of the matter is that the recent Supreme Court decisions, like West Virginia v. EPA, that a general allocation of power by Congress is constrained by the idea of a major question. Well, whether non-compete should be there or not is a major question, and the states disagree about it, and Congress has never addressed it. Why is FTC getting involved? And their story about it is that it's really been pushed down so that, sandwich makers at Jimmy John's are under non-competes, I think is the allegation. Well, that is maybe a problem, but it can be addressed by other people who aren't the FTC.
Yeah, and this is a straight up matter of state contract law. So the states are the ones that are best positioned to address this.
It's absolutely correct. And to wipe out the laws of all these states by Federal Trade Commission, fiat. And now here's the other way they're doing it. They're entering into consent agreements with companies that are willing to knuckle under to their nonsense. Now, sometimes they do it because of expense, right? You don't want to get in litigation. But these consent agreements come out. And then when you're the next company in the line, they send you a bunch of these consent agreements. You know what consent agreements are? If you're not a party to them, they're
non-binding.
No, they're best. I was going to say they were best used in your bathroom. That's it. The fact is they're nothing. And the court should not only not look at them, the court should penalize the FTC for citing a consent agreement as precedent for anything, because it is absolutely horrible that the FTC does this. They either get a weak company or maybe even a collusive company. Maybe they get the CEO of a company who doesn't really care about the issue, and they go against him, and it's like,
or one that's on the way out the door.
That's right. And so these agreements are also now they bind the CEO. So what's actually happened is that what the FTC is trying to do is say anyone who hires this guy, their company can't use non-competes either. And what does that do? Well, that's just like a non-compete. That guy who's under this order by the FTC now cannot move companies as easily, because who wants a guy who travels with them a violation of your contract rights? I don't. So the thing is, as far as you enter these agreements with the FTC, they're really non-competes for you. Nice
point, John.
It is an absolute horror, and it really shows the current leadership of the FTC doesn't really believe in limited government or administrative law. They believe in power. That's all they believe in, because
they're a hammer and they see nails everywhere.
You would not do this if you had any humility in what your job actually was. You wouldn't do it. Now I could,
or fidelity.
It's exactly right. The idea that they are allowed to, and don't forget, it's the majority of states allow some kind of non-compete, and to have the hubris to say that they're all wrong and you're right. And I say this as someone who thinks that they're overused and that they're unjust in a lot of cases. I'm not saying, but the idea that the Federal Trade Commission gets to do this after 100 years of development of non-compete law, that all the states and the judiciary and the Congress look at these things. What I find interesting would be a much closer case. But you could still fight back at it, but would be what the government also does federal contracting, right? And if they think that people under $60,000, that it'd be unfair to have federal contracts to somebody who doesn't let their employees move when they have no secrets or anything with a non-compete, if they made this a federal contracting question on a case-by-case basis, they could actually have more accurate studies behind it and all the rest.
Except guess what other area the FTC is not in charge of? Government contracting.
Right, exactly. But I was trying to think what federal thing would be allowed. And when Congress hasn't acted, there really shouldn't be any. And that was the only one I came up with where they might be able to make a case. But again, that would be for the parties that wanted federally contract. It wouldn't be for the whole world now looking at litigation with the FTC for doing what everyone's done and every state, what is lawful activity. This is lawful activity that they are trying to make illegal by administrative fiat, and that is an outrage.
Lawful activity and consensual activity. You don't have to sign these things if you don't want to. And John, I come at this the same way you do. I mean, the only lawsuit that my dad was ever in was a lawsuit over a non-compete clause that he had signed. And, I'm not going to go into all the details here, but I'll just say it was extremely broad, both in terms of duration and geographic area. He lost that case, and he had to leave the area where he was living in order to continue to practice medicine. But he signed it.
I know, and those medical, I've done those medical ones as well, and it's been really bad. But I'm always like, I can get 20.1 miles away because they routinely for at least
20 would have been fine. This was over 100 miles away.
That's nothing in Kansas, right? Anyway, it reminds me of the old joke that the English people say Americans think 100 years is a long time, and English people think 100 miles is a long distance. But in any event, yes, exactly. So you could be out of the real market and you still are bound by these things, and that is just not good. So we will be looking at the FTC. Comments are due. I think there's going to be a lot of comments. There already have been, and let's hope the FTC pulls in its horns. Because,
about 60 days, right? Is
it
March 20th, something like that?
That's it, March 17th, something like that.
Okay.
So St. Patrick's Day, get your comments in. But in any event,
beware the Ides of March.
Yes, exactly. So, but it's just overreach, and this FTC has shown that it doesn't believe there are any limits on it, none at all, and that is not good for an administrative agency to act upon anyone.
Welcome back to Administrative Static. Mark Chenoweth here with John Vecchione. And John, I wanted to tell people about something that NCLA did this past week that we don't often do, which is that we filed a petition with a federal agency asking for it to amend a regulation. And why did we do this? Well, because we took the issue all the way up to the Supreme Court and lost. And so we're kind of out of options. Folks may remember we talked about this case last year. It was the Buffington v. McDonough case. We had filed a cert petition with the Supreme Court over this veterans benefit issue. Our client, Thomas Buffington, had been discharged from the military. He had disability benefits relating to some tinnitus that he was suffering. And then he was recalled to active duty after 9/11 and served for a little bit. And then when he was discharged again, honorably, then the benefits would have started immediately after he was discharged. But there was a regulation that the VA had put into effect that said, first of all, they don't restart until you ask for them to restart. And they will, if you wait more than a year to ask for them to restart, then you can only go back a year for benefits. You can't go all the way back to when you left the military. And that's not what the statute says. And so we had asked the courts to take a look at this VA regulation and decide that it was inconsistent with the statute. Instead, what the courts did was look at the regulation and defer to the agency under Chevron. And we thought that was a problem because there's a substantive canon that suggests in cases of ambiguity that you should construe a statute in a way that's favorable to the veterans benefits beneficiary. But that is not what the courts did. And as I say, we took it all the way to the Supreme Court. We got a nice dissent from denial of cert from Justice Gorsuch. John, you may remember he said that our veterans like Mr. Buffington deserved better from the VA and from the federal courts, which I thought was a nice grace note on his dissent from denial of cert. But that still leaves Mr. Buffington and others in his situation in the unfortunate situation that they are denied some of the benefits to which they are statutorily entitled. So we took it upon ourselves, as I say, something we don't often do, don't make a regular practice of, but we decided this past week or so to file a petition asking the Department of Veterans Affairs to amend its controversial regulation regarding payment of benefits to veterans who have been deemed eligible for disability benefits, but who later return temporarily to active duty. And as I say, this regulation denies many disabled veterans the benefits to which federal law entitles them. We joined in this petition with Concerned Veterans for America Foundation, and together NCLA and CVAF are urging VA to do the right thing. So even though they won this case in court, we're asking them to amend the rule to reinstate disability benefits that are due to veterans who return to active duty the moment that they leave active duty, or I should say veterans who are discharged the moment that they leave active duty. So, Vec, I don't know whether the VA is going to act on this. As I say, they've won the case, so they could just stand by and rest on their laurels.
I do think the sign outside the Veterans Administration has that quote from Lincoln about he'll care for his children and his widow and all that, yeah. Right? And I do think that at least the VA, I have seen petitions to the VA where oftentimes it hasn't been fully brought to everyone's attention what's going on. And then the veterans organizations do have some pull to say this isn't right, particularly, look, he's asked for it, he deserves it. Why would you cut it off? Why would there be a statute of limitations that's not in the statute?
Right. And
so it makes sense, and it's kind of with their mission. I don't know if they'll kick real hard.
Well, I hope you're right. I mean, I think even the VA justifies this regulation on quite dubious policy grounds. The VA asserted in the Buffington litigation that the threat of benefit forfeiture for those who delay seeking the resumption of benefits incentivizes the veterans to file timely applications after leaving active service. That may or may not be true, but that is not what the statute calls for. And so such arguments do not justify ignoring the plain text of the statute. Moreover, I think this argument isn't all that well taken, because disabled veterans already have an incentive to notify the VA as soon as their active service ends, because they don't get payments until they notify the VA. The VA doesn't automatically find out. And I suppose that's another way that it could be changed. It could be that the military would be the one that would notify the VA when someone is discharged, rather than the service member themselves notifying the VA. But that's not the way it works right now. But in any event, the VA can't resume making payments until it knows that someone's active service has ended. So veterans have an incentive already to notify the VA to avoid delaying the receipt of their accrued benefits. So I think the fact that the VA is trying to justify this benefit forfeiture as an incentive, first of all, the incentive isn't necessary, and second of all, it's way too harsh an incentive to have the forfeiture of the benefit in that scenario. And it's 100% forfeiture. I mean, you just don't get the benefit if you delay in asking for it. So I'm interested to see what's going to happen here. But I think for our purposes, Vec, this is just another example of the ways in which the administrative state is ignoring statutory text and is benefiting from Chevron deference. Because in this litigation, I think it's significant that not a single judge involved in the litigation ever agreed with VA's contention that the current rule reflects the best reading of the underlying statute. No judge thinks that. We certainly don't think that. I don't even think the VA thinks that. But I think what the VA thinks is, aha, this is a plausible enough reading of the statute that we can get Chevron deference for it and save the VA some money. I think that must be what they're thinking. I don't know what other incentive they would have. And we heard that, Vec, in a couple of our luncheon laws last year from, I know, Roman Martinez, when he was here, talked about his time in the Solicitor General's office and that he dealt with federal agencies, that is their mindset, is how it's not what's the best reading of the statute, let's write the regulation that way. It's how much can we get away with that we can still get Chevron deference to and write this regulation in the way we want to write it.
Yeah, and it does show the, you talk about incentives. Well, Chevron deference has right there made a huge incentive for them not to come up with regulations that are based on the best interpretation of the statute. Isn't that the incentive there? The incentive is not to do the best job you can in following Congress's intention.
Well, that's exactly right. And the other thing I think that's maybe telling here is that when the statute was originally passed, the VA had written and implemented a different regulation back in 1961 that mandated immediate resumption of disability payments following a veteran's release from active duty. So this newer regulation, and it's not brand new, it's been around for, I don't have the year in front of me here, but it's been around for a while, maybe, 20, 30 years, something like that. I'm not sure which administration implemented this new version of it. But the VA itself recognized when the statute was first written that immediate resumption of disability payments following a veteran's release from active duty was what Congress really had in mind. So to me, this is a good example of, and I should go look at the date on this because I'd be curious whether it was before or after 1984 that this new regulation got written, because I bet you it's after 1984.
Why?
Because that's when Chevron was passed. And so, I think in that 1961 to 1984 time period,
that was good.
Did I say it was passed? Oops. When the Supreme Court, when a 6-judge plurality, rump Supreme Court handed down the Chevron decision and accidentally worked a tremendous damage to the Constitution of the United States. But in that 1961 to 1984 period, the Department of Veterans Affairs looked at the statute and said, well, I think what the statute says is immediate resumption of disability payments following a veteran's release. Then post-Chevron, when the VA got used to getting deferred to all the time by federal courts, they said, I wonder if we could write a rule that changes. There's no change to the statute. None. They just changed the regulation and got away with it because of Chevron deference. And so kudos to our colleague, Rich Samp, Senior Litigation Counsel here at NCLA, who was the driving force behind both the Buffington litigation and this petition to the VA. As Rich said in our press release that we issued when we filed this petition, VA should not adhere to a flawed and ungenerous interpretation that denies benefit payments to deserving veterans like Mr. Buffington. VA's obligation is to adopt the best reading of the statute. In this case, that means resuming disability payments to veterans as soon as they are released from active service. And I think Rich is right about that.
And we'll see what happens. Now, as I recall, and correct me if I'm wrong, if a petition isn't acted on in like 2 or 3 years, you can bring a suit that they haven't responded to you, right?
Yes.
That is your remedy.
That's correct.
Right. And they don't have to do what you want, but they do have to have something. They have to at least say something. So perhaps it will cause some thought over there.
That's the hope, that it'll cause some thought, that the folks who make these decisions on the policy side will at least have the opportunity to reconsider this. The litigation itself was probably shipped off to DOJ or something. And look, as I say, they won the argument in court. They're still wrong in policy, and we're giving the VA an opportunity to clean up their own act.